Have you ever watched someone realize in real time that they had made the worst decision of their life? Not in hindsight, not years later, reflecting with regret, but in the actual moment when the consequences are unavoidable and irreversible. I've seen that look in courtrooms more times than I can count. But yesterday, it was different. This wasn't a verdict. This wasn't an arrest. This was sentencing. After months of pretrial maneuvers, after all opportunities to cooperate had passed, after the window for a plea deal had long closed, the defendant stood there in the courtroom listening to the judge recite the sentencing calculation. And in that moment, the reality hit. He understood, fully and completely, that he was about to go to prison for decades, and when that understanding hit, he broke. The sentencing hearing had been proceeding normally for about 40 minutes. The judge had methodically reviewed the presentence investigation report. She had heard from the prosecution about the scope of the fraud, the number of victims, the staggering financial loss, and the societal harm caused. She had listened to the defense attorney argue for a sentence at the low end of the guidelines. Standard procedure. Everything was unfolding as expected. The defendant had been standing at the defense table with his attorney, hands clasped in front of him, staring at the judge, waiting for the inevitable. But then the judge began walking through the sentencing factors in detail. She outlined the nature and circumstances of the offense, multiple counts of fraud committed over several years, involving careful, systematic deception. She reviewed the defendant's history and characteristics, no prior criminal record, yet a glaring lack of genuine acceptance of responsibility. She highlighted the need for the sentence to reflect the seriousness of the offense, including tens of millions of dollars lost by victims and the erosion of institutional trust. With each factor, the defendant's posture shifted. His shoulders began to sag. His breathing became shallow and faster. By the time the judge reached the guideline range calculation, he was visibly trembling. The court had determined that the applicable guideline range was 30 to 37 months, just a few years in prison. But the judge was clear that aggravating factors warranted a significantly higher sentence. And then, in a voice measured yet uncompromising, she said it. The court was contemplating a sentence of 20 years. 20 years in federal prison for fraud. At that moment, the defendant's knees buckled slightly, and his attorney grabbed his arm to steady him. The judge continued. She noted that the defendant had shown no remorse, had lied on the witness stand, attempted to destroy evidence once the investigation began, and displayed a level of criminal intent warranting a substantial sentence. He began shaking his head, almost imperceptibly at first, whispering something to his attorney. His attorney whispered back, trying to calm him, but the defendant was beyond composure. He turned toward the judge, and finally, a raw, desperate sound escaped him. Not quite a scream, not quite a sob, something in between. Then words followed, loud, frantic. "I'll tell you everything now. I'll cooperate. Please. I know names. I have documents. Just give me a chance." The judge paused, raising a hand as she had been reciting her written sentencing statement. "Sir, you need to compose yourself," she said calmly. He ignored her. He continued, shouting, "I can give you the accountant, the lawyer who set it up, the bank executives who knew everything. Just please, not 22 years. I'll tell you everything." The attorney was trying desperately to calm him, pulling on his arm, but the defendant was beyond listening. He had gone from measured to completely unhinged in less than 30 seconds. The judge struck her gavel, hard. The sound echoed through the courtroom. "Mr. Johnson, you will stop speaking immediately or I will have you removed." Finally, he quieted, but he was still trembling, tears streaming down his face. The judge, in a tone I have rarely heard, almost sad rather than angry, addressed him. "Mr. Johnson, the time for cooperation was 2 years ago when you were first approached by federal agents. 18 months ago when you were indicted and offered a plea agreement. 1 year ago when the prosecution made a final offer before trial. 6 months ago, during trial, when you could have stopped lying and started telling the truth." The time for cooperation is not now. Not after a jury has convicted you on every count. Not after you have forced the government to prove its case through a lengthy trial. And certainly not after I have announced your sentence. Let that sink in. The defendant was staring at her in disbelief. The judge continued, methodically, "You had countless opportunities to do the right thing, to accept responsibility, to cooperate with the investigation, to help identify other wrongdoers. You chose not to take any of those opportunities. You chose to lie, to obstruct, to fight every step of the way. And now, when faced with the consequences of those choices, you want to cooperate. That is not how this works." The courtroom was silent. The sentence stood, 22 years in federal prison. 2 U.S. Marshals stepped forward. The defendant began pleading again. "Please, just let me talk to the prosecutor. 5 minutes. I can give you so much information, please." But it was too late. The marshals guided him toward the holding cells. His attorney followed, trying to calm him, but the defendant continued shouting, "I'll cooperate. I'll tell you everything, please." When the door closed, the courtroom was quiet. The judge addressed the prosecutor. "Counsel, I assume you heard the defendant's statements?" "Yes, Your Honor," the prosecutor responded. "Is there any interest from the government in pursuing cooperation at this stage?" The prosecutor was measured. Yes, the government always welcomes cooperation, but she noted the defendant had been offered multiple opportunities over 2 years, all rejected, and had actively obstructed the investigation. Any cooperation now would be evaluated in light of that history. Translation: too little, too late. From a legal perspective, this is critical. The defendant gambled repeatedly and lost. He thought he could beat the case at trial. He thought the jury would acquit or convict on only some counts. He lost that gamble. Then he hoped for a light sentence, maybe even below the guidelines. He lost that gamble too, and now, facing 22 years, he finally realizes he should have cooperated from the start, but at this point, his cooperation carries almost no value. Early cooperation in a criminal investigation is invaluable. It is the moment when a defendant can actually influence the outcome of their case in a meaningful way. Prosecutors rely on insiders to help them build the structure of the case, identifying evidence, providing details that may otherwise remain hidden, and pointing to other potential targets. This kind of cooperation is not just helpful, it is often essential to fully unravel complex schemes, and the system recognizes that. When someone steps forward early, federal law allows for substantial sentence reductions. These reductions can be dramatic, sometimes cutting decades down to just a fraction of the potential sentence, depending on the value of the cooperation. But what happens if that cooperation comes too late? If a defendant waits until after conviction, after the trial has proven guilt beyond a reasonable doubt, or even after sentencing, the calculus changes completely. At that point, the cooperation is worth almost nothing. The prosecution already has the evidence, the case is established, and the judicial system no longer needs the insider guidance that would have made early cooperation so valuable. Any information the defendant provides now is evaluated with extreme skepticism. Why? Because the credibility of someone who has spent 2 years obstructing, lying, and avoiding responsibility is inherently compromised. Think about it from a practical standpoint. Federal prosecutors ask themselves, after years of deception, can we trust this person now? If someone has repeatedly misled investigators, lied on the stand, or destroyed documents, there is little reason to assume their newfound willingness to cooperate is genuine. Even if the information is technically accurate, the court and prosecution will view it through the lens of self-interest and desperation. That credibility gap is critical. In the eyes of the law, credibility is often just as important as the content of the testimony itself. There is also a procedural element that cannot be ignored. Federal sentencing is not flexible in the immediate sense. Once a judge announces a sentence, it is final, barring specific legal mechanisms. One of those mechanisms is the provision of substantial assistance to other prosecutions. If a defendant can provide genuinely useful information that leads to the prosecution of other individuals, the government may file a motion for a downward departure. But this is a lengthy process, often taking months or even years. The cooperation must be formalized, documented, and validated before the court can even consider adjusting the sentence. There is no instantaneous reward for last-minute confessions or frantic claims of insider knowledge. The lesson is clear. Timing is everything. Cooperation that would have been incredibly valuable in month 1, capable of generating massive reductions in sentence, loses most of its value by month 12. And by the time a defendant is pleading for leniency after sentencing, as we saw in the courtroom, the opportunity has effectively expired. The system is designed this way for a reason. It incentivizes responsible, honest, and timely behavior. It penalizes calculated delays, obstruction, and attempts to manipulate the process for personal gain. What I witnessed yesterday was the cumulative impact of every decision gone wrong. He rejected the initial plea offer, 3 years. He went to trial. He lied on the stand. He forced the government to expend extraordinary resources proving every element of each charge. And now, instead of 3 years, he faces 22. That 15-year difference is the price of his choices. Screaming, "I'll cooperate," in the courtroom cannot undo that. Some may ask, is it fair that the system penalizes those who exercise their right to trial? Should cooperation be required for a reasonable sentence? These are valid questions. The justice system does create an incentive structure. Early cooperation can dramatically reduce sentences. Refusal to cooperate or active obstruction can lead to maximum penalties. This is designed to encourage accountability and allow prosecutors to dismantle criminal schemes efficiently. The judge's tone was instructive, not angry, not vindictive, calm, factual. She explained the reality. The defendant missed the window for cooperation. Last-minute desperation does not change the calculus. Choices have consequences. That's how the legal system works, and how experienced judges convey justice without gloating. This case also exposes something fundamental about human nature. We convince ourselves we have more time than we do. We wait, watching, testing the waters. But suddenly, the window closes. Opportunities vanish. And when that happens, what remains is desperation, screaming into the void, offering things no one wants anymore because we waited too long. In criminal cases, this dynamic is constant. Defendants rarely cooperate at the first opportunity. They wait, thinking they can time their disclosures to maximize advantage. They hold back information as leverage, hoping to see how the investigation unfolds, trying to keep their options open. They convince themselves that the best move is to delay, to play the long game. But here's the reality. Cooperation depreciates over time. The legal system rewards early honesty and punishes procrastination. A defendant who steps forward immediately after being approached by federal agents might be looking at a 75% reduction in sentence. That same cooperation, delayed by a few months, could drop to 50% or even 30%. By the end of a year, after trials, motions, and investigations have run their course, the same information might only carry a 25% reduction or less, and by the time the defendant is standing in the courtroom, already sentenced, desperate, and pleading for leniency, that cooperation may be worth nothing at all. The window has closed, the leverage is gone. The system simply does not reward last-minute desperation. What happens next is mostly procedural, but the procedures themselves are telling. The defendant may attempt to provide information from prison. This can take several forms. They might write letters to federal prosecutors outlining what they know. They could be debriefed by agents assigned to the case. They may participate in interviews or submit formal affidavits to assist ongoing investigations. All of this is possible. It happens in federal prosecutions from time to time. And the government does review any new material carefully. But here's the catch. Even if the information is substantial, there is no guarantee that it will lead to immediate or meaningful reductions in sentence. For the court to consider reducing a sentence, the government must file a motion known as a substantial assistance motion. This is not automatic. It is discretionary. Prosecutors review the quality, credibility, and utility of the information, and they may choose to act or not. And even if they file the motion, the judge must then evaluate the request before issuing any reduction. This process can take months, sometimes even years. It is not a quick fix. The implications of delaying cooperation are stark. The defendant has already missed multiple opportunities: the initial approach by federal agents, plea negotiations, pretrial offers, or even early trial cooperation. Each of those moments was an opportunity to shape the case and mitigate exposure. Now, by waiting until the sentence is pronounced, the defendant finds that the law offers no shortcuts, no immediate escape routes, no redo button. What might have been a dramatic reduction in sentence early on is now either heavily diminished or completely lost. This illustrates a fundamental principle in criminal prosecutions. Timing is everything. The system is structured to reward those who act responsibly, who accept accountability, and who provide meaningful assistance when it matters most. Those who delay, obstruct, or manipulate the process face the consequences. And in the courtroom, those consequences are often made painfully clear in the defendant's moment of desperation, pleading for leniency after having exhausted every window of opportunity. In other words, missed opportunities have long-term consequences. They cannot be undone. Letters, interviews, and debriefings from prison may help someone slightly, but they will never fully compensate for the failure to act when it mattered. The lesson is simple. In federal prosecutions, value is attached not just to what you know, but when you act on it. Timing and honesty are the currencies that determine whether cooperation can save a defendant from the maximum penalties the law allows. Delay too long and the currency becomes worthless. What I witnessed yesterday was more than a sentencing hearing. It was a lesson in decision-making, timing, and accountability laid bare in real time. It wasn't just a procedural step in the justice system. It was a live demonstration of how every choice a person makes compounds over time, creating consequences that are often irreversible. Every single decision the defendant had made along the way contributed to the moment he faced in the courtroom. The gamble of avoiding cooperation early in the investigation, thinking he could hold back information and still protect himself. The gamble of lying on the stand, believing he could manipulate perception and convince the jury of his narrative. The gamble of forcing a trial instead of accepting a plea deal, imagining he could beat the case or at least reduce his exposure. Each choice, rationalized at the moment as a strategic move, layered risk upon risk, and all of those risks converged into a single, crushing, and unavoidable reality. The desperation he displayed was raw and human. It wasn't theatrical or calculated. It was the unfiltered reaction of someone suddenly confronted with the full weight of their past decisions. The shaking, the pleading, the frantic words, all of it made clear what happens when timing is ignored and opportunities are wasted. You could see, almost physically, the realization hitting him. The world he thought he controlled had slipped away, and there was no turning back. The lessons for anyone observing are stark and immediate. In the justice system, timing matters as much as truth. Early cooperation isn't just beneficial, it can be transformative. The difference between acting in month 1 versus month 12 isn't a few months of sentence reduction. It can be the difference between a minor penalty and decades behind bars. Conversely, delay, obstruction, and denial amplify consequences exponentially. Every lie, every strategic pause, every attempt to outlast the system increases exposure and diminishes credibility. Human nature compounds this problem. We all convince ourselves, in one form or another, that we have more time than we actually do. We believe we can wait, assess, and act later when the stakes are clearer. We imagine leverage where there is none. We think we are always in control of outcomes that, in reality, are slipping through our fingers. But yesterday's courtroom demonstrated how harsh and unyielding reality can be when those illusions collide with consequences. The window closes faster than expected, and once it closes, no amount of pleading or frantic offers can restore what was lost. What I saw will stay with me for a long time. It was a vivid reminder that decisions have consequences, and those consequences can arrive suddenly, with more force than anyone anticipates. It illustrated in stark detail the human cost of misjudging timing, of miscalculating risk, and of overestimating control. The courtroom was silent in parts, chaotic in others, but the lesson was loud and clear. Every choice matters. Ultimately, yesterday was more than a legal proceeding. It was a human story about accountability, the limits of strategy, and the unforgiving nature of time. The defendant's fate was sealed not by chance, not by malice, but by a series of calculated choices that failed to align with reality. For anyone watching or anyone navigating high-stakes decisions in life, the message is simple. Act when it matters, tell the truth when you can, and never assume the clock will wait for you. Yesterday's scene was a courtroom lesson that transcended law. It was about life, choices, and the consequences that follow, inevitable and unstoppable.